All right, we got a new case that we were looking at from the public record. This is the USCIS delay hits 45 months. So they filed a Mandamus lawsuit. Federal lawsuit demands answers. Let's take a look at this case. This case is or was filed this year in February 4th, 2025 in the U.S. District Court for the District of Maryland. And it looks like there are two plaintiffs, and they sued a lot of individuals in their official capacity as part of various agencies as defendants. And the plaintiff's original complaint is for the writ of Mandamus and for the violation of the Administrative Procedure Act. All right, and let's take a look. So here, the introduction, it says, on April 9, 2021, the plaintiff and U.S. citizen spouse, plaintiff's song. So plaintiff's song is the U.S. citizen spouse, lawfully filed Form I-130 petition for alien relative petition with the USCIS, naming his spouse as a beneficiary to become a permanent resident of the U.S. On April 21st, 2021, plaintiff timely, completely, and lawfully filed Form I-485. It looks like they filed shortly thereafter I-485 application to register or adjust status and pay the associated fees. And this action is brought as a result of defendant's failure to adjudicate the plaintiff Ann's Form I-485 application to register permanent residence within a reasonable period of time. The application has been pending for a period of 3 years and 9 months, almost 4 years, over 45 months without any resolution. All right. And they're saying the delay in making a decision on plaintiff application extends well beyond congressional guidelines of 180 days for immigration benefits under 8 USC 1571. Okay, and here are the parties. So again, it's talking about the plaintiff is a resident of and a citizen of the U.S., and the spouse has been approved for Form I-130 petition for alien relative, allowing beneficiary qualification for plaintiff and to apply to adjust her status to that of a permanent resident. Okay, and it's talking about as a resident, the plaintiff and is a resident of Maryland and a citizen of China. She's a beneficiary of an approved I-130 petition for alien relative filed by her U.S. citizen spouse, plaintiff's song. The approved Form I-130 allows beneficiary qualification for plaintiff Ann to adjust her status to a permanent resident of the U.S. Okay. And plaintiff Ann is also the applicant of a properly filed Form I-485. So then they're going to list all the defendants here. They're going to list a couple of different agencies. And they're going to talk about the jurisdiction and venue. They're saying that the court has jurisdiction to hear this complaint because this is a federal mandamus action brought to compel defendants to perform their statutory duties owed to the plaintiff. And then this court has additional jurisdiction by virtue of the Administrative Procedures Act because the plaintiffs are seeking judicial review of inaction by one or more of the defendants. Remember, they have named more than one defendant, and plaintiff Ann has repeatedly requested defendants to make final decision on her application. And it looks like she has exhausted all her administrative remedies. And plaintiff has supplied the USCIS with documents that establish plaintiff eligibility for approval over Form I-485. There are no further administrative remedies available for plaintiff to utilize. All right, so some of the factual allegations that's going to talk about here, if we already discussed it, but let's just take a quick look at it anyway. It looks like plaintiff and U.S. citizen spouse, plaintiff song filed and paid for the required government fees for Form I-130 petition for alien relative naming his spouse, plaintiff Ann, as beneficiary. Plaintiff Ann filed and paid the required government fees. Plaintiff Ann appeared for her required biometrics appointment. Plaintiff appeared at the USCIS Baltimore field office, where they appeared for the required interview before a USCIS officer. Following the interview, they did issue an RFE, request for evidence, for plaintiff Ann, which the plaintiff responded to within the allotted time. Plaintiff approved plaintiff song's Form I-130 petition. Since plaintiff Ann completed her required biometrics appointment interview, the required RFE, USCIS has made no further request for evidence or information from the plaintiff, and neither have they completed adjudication over Form I-485 application. And she has made numerous increase over the 3 years and 9 months. I mean, almost 4 years, 45 months, over 45 months with the USCIS, and it requested the adjudication over application. And the increase have not resulted in any meaningful response from USCIS. Plaintiff Ann's application now continues to be pending with the USCIS, with a total of, again, they keep repeating it, 3 years and 9 months. It extends well beyond the congressional deadline for 180 days. In addition to the expectations set by Congress, USCIS published historical averages processing times in 2021 of almost 13 months for adjudication of Form I-485. The time is higher now on how long it's taking. Plaintiff Ann's Form I-485 has been pending for over 45 months, which is almost 3.5 times the average historical processing time. The defendants have refused to provide further explanation, which would merit the need for over 45 months of processing time. All right, so basically the count one is violation of the APA Form I-485. And it says that plaintiff Ann has a statutory right to apply for adjustment of her status to a permanent resident by filing Form I-485, the application for adjustment of status. And the defendant have a duty to adjudicate plaintiff Ann's application within a reasonable period of time. There is no other remedy available to the plaintiff, given the defendant's lack of reason for not making a decision on plaintiff Ann's application for over 45 months. Plaintiff Ann's application has been pending for an unreasonably long period of time. And what they're requesting the court to do is order the court to enter an order mandating a time certain to adjudicate plaintiff Ann's application, in the alternative that the court compel defendants and those acting under to perform their duties to adjudicate plaintiff Ann's application immediately. And then finally award attorney's fees based on the equal access to justice. All right, so this is another example of another Mandamus lawsuit that we found in public record. It is all available in public record. If you like this, subscribe, give me a thumbs up so we can bring more of these types of publicly available cases. Thank you very much for your time today. Bye-bye.